In a moment, Rachel's going to start us off with an overview of the distinction between matrimonial property and non-matrimonial property in farming cases, and we'll go through a case study in which the bulk of the property was non-matrimonial. I'll then expand on the issues concerning gifts and inheritance in farming cases, and we'll discuss a case study concerning issues with gifts and inheritance. Rachel will highlight key considerations when drafting prenups and postnups for farmer clients or for their spouses. I will then finish with some practical tips for dealing with farming cases and for raising or defending court actions. Please note, to illustrate our points, we're going to assume that one spouse is the farmer and the other spouse or civil partner has a lesser or no role in running the business. We'll refer to the farmer or the other spouse rather than referring to them as husband or wife to avoid stereotyping. The other spouse will be the one seeking financial provision in negotiations or on divorce.
So a question that is frequently asked by clients is whether agreements of this nature are truly binding. Whilst there is always the possibility that a court could strike an agreement down, if the agreement is set up properly, that reduces significantly the possibility of this. It is important to bear in mind the provisions of Section 16 of the Family Law Scotland Act 1985. So that states at Section 16.1 that where the parties to a marriage or the partners in a civil partnership have entered into an agreement as to the financial provision to be made on divorce or in dissolution of the civil partnership, the court may make an order setting aside or varying any term of the agreement relating to periodical allowance, where the agreement expressly provides for the subsequent setting aside or variation by the court of that term, or the agreement or any term of it where the agreement was not fair and reasonable at the time it was entered into. So what we are focusing on here would be whether the agreement was unfair and unreasonable at the time it was entered into, and that test would be looked at on the balance of probabilities. There are a number of steps that can be taken to ensure that so far as possible, the agreement will not be struck out on this basis.